the first to know Nsem-Pii TV.
Sir, Jebekaya recently and a former Chief Justice, Gertrude Tokonu, and I'm the lead counsel, lawyer Ayikoo Otoo, etimi ekoko piemu ewo court to say, as Chief Justice, name Supreme Court judge there. Government any power say obetimi every sinti court onhwe na onka asem no na ono emameye ni Supreme Court judge ewabra onye Chief Justice na sa asem we na Attorney General yura Dr. Dominic Ayine ekame say ekwan a former CJ a lawyer for no any abre no okono abrone so a me no eka say de wa refer asem no at the Akwakupiemu, it was Supreme Court for interpretation. No, and lead counsel at the Yemami Gertrude Tokonu, and so etimi a challenge ne pa enye asem kotwa ono HSA unconstitutional. Na odi yanko ni yanko tie lawyer ni Ayikoo Otoo.
Well, I think the point we are making is that the Constitution makes provisions for what ought to be done, but when those provisions themselves are not followed, both in the letter and the spirit, then it will amount to an unconstitutionality. Yes, there is Article 146, which makes provision. What it requires is that there must be a petition. So the president receives the petition, he refers it to the Council of States, and then a prima facie determination should be made. Those who are not lawyers can be educated on the case of Ayikoo, which said that although the prima facie determination was not written in the Constitution when it comes to the CJ, because she's also a Supreme Court judge, and therefore a Superior Court judge, those provisions should also apply to it. So the Supreme Court read those provisions into the Constitution and says that, look, try in a case also make a prima facie case, in the case also give her the petition. So you see that right from the beginning, the petition was never referred to the Chief Justice. It was only being discussed in the public space that petitions have been received for removal, and that the president has even started consultations with the Council of States. But the Supreme Court had then earlier directed that, look, in these matters, give the petition to the person affected, hear a side of the story, and then take that into consideration, making a prima facie determination. It took her to write to demand it. Then, when she demanded, she was even given time limitation that you have to respond within 10 days. Thereafter, we were told that a prima facie determination has been made, and therefore the president has proceeded to set up the Poor Man Committee to investigate the matter. Now, as we speak, the said prima facie determination was never served on the Chief Justice. That, in our view, is a constitutional breach. You have the Constitution says make a prima facie determination. Now, prima facie means ordinarily that at first blush or on the face of it, we think something had happened. It is after the people have gone, the committee has gone into the matter, that the committee can now confirm or say that no, nothing really happened. So when you set up a committee and you invite the person to appear, are you not saying in effect that now you are going there to lead evidence to show whether or not our prima facie determination was properly done? How do you expect that person to go and do it when she is not served with the prima facie determination? And I am on record as saying that we have not been served, and I'm saying so up to now, that she has never seen whatever it was that the committee, so that you find that in the statement issued, we were saying that yes, that there was a denial of due process because she was never served with a copy of the judicial the prima facie determination which was made. I hope that point is very clear at this stage.
Right. Lawyer, you state clearly, and it's very unequivocal, that the Chief Justice was never served a copy of the prima facie determination. But given Article 146, is such service expressly required from the President that he will indeed serve the Chief Justice? Under Article 146, is he expressly required? Is he expressive?
You are dealing with a constitution, and therefore it's not everything that will be written black and white in a constitution, but you have to look at the letter and the spirit of the law, and even go back to look at the preamble of the constitution. We have been talking about the rule of law. So the rule of law also looks at procedural fairness. So if you're asking me to come and defend myself because you have made a prima facie case, what am I coming to defend myself against? It's the constitution which says we should do the prima facie determination. I just told you about Jechum, that the words which were not there were even on the purposive interpretation read into the constitution. So this one, even if you don't see it there in black and white, it is part of procedural fairness that you are asking me to come and defend myself against something. What is it that you have found? Do you understand the point I'm making? What is it that you have found for which I should come and... Because as I said, prima facie is not the end. It only says on the face of it, I have found something. So let me give you an example. We went there. There was an issue about 14,000 Ghana cedis given to her as interest that she had not accounted for. It was in the papers already, making the rounds. Taylor and other people were using it to bash her. We went there. The director of finance was brought in to come and testify. She admitted that upon her return from the trip, she retired the entire 14,000 interest given to her, accounted for it, and gave back about 9,000 to the judicial service. So now ask yourself, if you make a prima facie determination based upon this, and it turns out at the trial that in fact there was no such infraction of any law at all.
Right. Is that the reason? Is that the reason why, lawyer, you continue to refer to the removed Chief Justice as still Chief Justice? I mean, she's been removed from office by the President. You're saying it's unconstitutional, and you're still referring to her as the Chief Justice. What's your basis for that identification?
Oh, these are just semantics. I don't think we should worry ahead about it because the matter is in court, isn't it? She's gone to court to challenge all those things that the recommendations made were perverse. So let's leave those things for the court to look at if they come to a different conclusion. Let me point out, these days most of you immediately, I'm having a conversation with a journalist and he says senior. Then it immediately sends a message that he has finished law because now everybody is a lawyer. We are able to call 1,000 people to the bar at the same time. So although you have not referred to me as senior,
and that could be, lawyer, that could be a conversation for another day.
No, I'm saying that also gives the impression that many people now understand. I wanted to bring in something. Are you aware that Kwame Nkrumah removed a former Chief Justice along with other people from the bench?
Right.
And one of them was Edward Akufo-Addo. And you remember that this person came back and became Chief Justice of the Republic of Ghana. So, I mean, the fact that somebody has been removed does not mean the end of the world. That's what I'm saying. She has never said anywhere that she is above the laws of this country. She's always only saying that, look, use the procedural fairness, do what the Constitution requires, and if you remove me, I will accept it. But if you are using things, other means of doing that, then that's not fair. And if as a judge over the years I've been defending the rights of others, then why should I be, subjected to this kind of treatment and then I'm expected to just keep quiet? You understand?
Lawyer,
So,
yeah.
as I've given you that example, Akufo-Addo was removed from the bench for giving a judgment that Kwame Nkrumah didn't like. He was brought back and became a Chief Justice under the Second Republic.
Now, before we come back to some of the key concerns you have raised, you spoke about the matter being in courts, i.e. the ECOWAS courts. What's the status of state of affairs over there?
No, it's not only the ECOWAS court. You know that she went to court earlier on,
right,
to challenge some of the procedures being used. Unfortunately, we were not given a date for hearing, but when the Attorney General filed what he called a preliminary legal objection that some of the matters are pending before the Supreme Court or that the Supreme Court had decided on them, which were not true in any case, because an interlocutory ruling does not deal with the substantive matter. And all that had been done at the Supreme Court was nothing more than interlocutory rulings. But I want to say those things, and then he was quickly given a date for hearing. So that application is still pending. By the end of the day, they said, well, they have upheld the preliminary objection that the matters are pending before a Supreme Court. Meanwhile, as we speak today, no date has been fixed. And then we got to put it in perspective. You know that under the Constitution, any Ghanaian can ask for interpretation. So you don't need any special interest in the matter to ask for interpretation. And so that you find that in, for example, Ajay, it was not Chief Justice Akwa who went to court. Someone else went to court. So there are about 5 cases pending. Only one actually can be referred directly to the leadership, the Chief Justice. Only one. The rest came from other Ghanaians. But they keep saying that, she's doing foreign shopping, she went to this court, she has gone to this. She has not. It is other Ghanaians who have gone to court to try and test. But the point I'm making is that no date has been given for any of them, though the processes are ready for hearing. So those ones are pending. So some are pending in the Supreme Court in Ghana, some are pending in the High Court in Ghana and the ECOWAS court. With the ECOWAS court, if you recall, the court adjourned to rule on interim measures. That is whether or not the warrant of suspension was proper, whether that warrant of suspension could be set aside, and whether she should continue to be in office until the committee had given or its recommendations. The case has been adjourned for ruling. Now, while all these things are pending, the committee, again, there were 2 more petitions to be heard, which the committee said they had adjourned to a date. Then they quickly rushed and went and presented one. Based upon the one that they presented, quickly the president acted on it and removed it. Are these all fair? Is it part of the rule of law? That don't we all say, you are journalists, you are always being warned that when cases are in court, we don't have to discuss the merits. Maybe you can talk about the procedures, but don't go into the merits. And all these things are pending. And His Excellency the President are going ahead to remove it.
Let me flip back to the op-ed that you wrote, and in terms of the key concerns you raised, and particularly I want to look at the omission of audits or management letters. You claim that the committee ignored a key audits management letter and related to the evidence. Did you formally bring this to the committee's attention? Was it through a motion or submission?
Well, maybe you are not one of my genius, because these are issues that those who are lawyers will know, that when you go to court, you present your case either through viva voce evidence, that will speak, or through documentary evidence. So in fact, it was part of the evidence that we tendered. And when the judicial the director of finance was called, she came and confirmed. Now, let me take you through this whole idea of the auditor's report. You see, every public organization that spends government money is subject to audit. So once a year, the Office of the Auditor General will send its officers to go and look at the books. They want to see whether indeed you have used the monies appropriated to you by the government in the proper way in which they ought to be used. You normally will send a budget, so they will look at the budget and give you money. Now you have to apply the money according to your budget. When it is clearly seen that you misappropriated the money or misapplied the money, then issues will be raised. So at first blush, when they come and they see things for which they need justification, they will ask the person called the spending officer that you are the one in charge of ensuring that this budgetary allocation in terms of the monies given to you are properly applied. How come that you did this and you did that and you did that, which in our view are all against the financial regulations of the country constitutionally or otherwise statutory? Then they give the opportunity to the person to react. So they say they call it either an audit query or an audit observation. Now, when this thing is given, it is the spending officer who must explain. So in this matter, when the query was raised, the judicial secretary, who is the spending officer, gave an explanation as to how monies are spent on travels, because they have what they call a travel policy. She explained the travel policy that when the head of judiciary or any person is traveling, that person has a right to go with one other person. The judicial service itself, by their travel policy, has something they call per diem, which they give to the person. And that when he's traveling with one other person, that person will be entitled to half of whatever will be given to her. After she gave this explanation, the management letter then came, which is the final report that, well, we have now taken your responses into consideration and we are satisfied that nothing untoward happened. There was no misappropriation, misapplication, or whatever offense. And so in the management letter, this issue of travel or buying ticket or per diem was never raised. We gave it to her to ask her to go through and tell the committee if it was ever raised in the management letter, and she said no. So that ended the matter. Now, this report was before the committee, and if you look at the 3 grounds for which they said the Chief Justice should be removed, one of them is that she bought, the Judicial Service bought ticket for the husband and the child when they traveled with her on 2 separate occasions, and that was wrong. Now, what do you think has happened? Is that not a suppression of evidence? Because this evidence was before them. An audit report is done on an entity which is a government, agency, department, or a ministry. And they have done the report and they found nothing wrong with it. Only for the committee, which had the report in front of them, to suppress it and still say that as for them, they have found something wrong. Is that fair?
Now, you also mentioned, particularly on pending litigation and the timing for the appointment, or rather the nomination of a new Chief Justice. You say that there are pending cases before the Supreme Court, and yet the President proceeded with the nomination of another Chief Justice. Some critics have said that there's no constitutional or equitable duty to await resolution before the President's act.
That's why I told you that then we should go back to look at what we call the preamble of the Constitution. Did we say that we want to live under the rule of law? We said we wanted to live under the rule of law. It's one of the cardinal principles underpinning our constitution, the rule of law. And when there are cases pending, is it not only fair that you respect the judiciary, the right of the judiciary to determine those cases? In other words, we also believe in separation of powers. So we have the executive, we have the judiciary, and we also have the parliament, the legislature. These are three arms of government. Together, they come to rule this country. And so where the judiciary is seized with a matter, and then the executive says, I don't care two hoots about whatever it is that is pending. We are going ahead. We're going to set up. We're going to appoint somebody new. I'm asking you, first of all, does it show any fidelity to the Constitution, the rule of law, and what about separation of powers? How are we treating the judiciary at this stage? These are the issues we are raising.
But lawyer, would that also not delay or impede the continuity of the judiciary, justifying that a nomination without pending suits? I mean, judicial process needs to move on. And
the person has been suspended since April. Judicial processes have been ongoing. Has anything stopped? Since April, she was suspended from office. And the person who has been nominated was asked to act as the most senior Supreme Court judge. And he continues to act. What has changed?
Interesting. We're still here on the Assassin Breakfast Show. We're speaking to one of the lead counsel, actually the lead counsel for the recently removed Chief Justice Gertrude Araba-Tokone, in person of renowned legal practitioner and lawyer Ni Ayikoo Otoo, giving us the key concerns that have been raised in that op-ed he wrote yesterday. Lawyer, I want us to talk about the demand you're making in terms of the absence of the written reports to the removed party. You demand that your clients be served with the committee's reports and recommendation. Now, that's Article 146 again, and I'm quoting that article because it's within the ambit of that article that this whole removal has been occasioned. Does Article 146 or any judicial decision expressly require the resigned or removed